Supreme Court issued two new opinions today that are worth talking about. One involves Obamacare. We spent a lot of time talking about Obamacare on this channel because it's kind of one of these cases that just never goes away. And I want to frame out what's happening here. But the big news is Obamacare is here to stay. This has been its third time at the doors of the Supreme Court, and it's not going anywhere. You know, this is a good example. When the powers that be want something to happen in this country, it gets done. There's nothing you can do to stop it. This was one of those situations. And I want to take you back a little down a history memory lane and sort of synthesize the journey that we've been on with Obamacare. And, you know, this is loose, generally speaking. So, you know, I'm playing sort of hard, loose with the facts because it's just a general summation of it. But if you recall, what happened back when Obamacare was being debated, back when Congress was kicking this thing around, it was almost not going to pass. In fact, there was a big election that was taking place regarding a senator named Scott Brown. And the country, the Republicans, the conservatives sort of rallied around Scott Brown to elect him to the Senate so that he can go and be that final vote that sort of changes the balance of power so that Obamacare never got passed. Well, what happened was Scott Brown got elected, didn't stay there long, but they actually changed the balance of power essentially in the Senate so that Obamacare could not be passed. But what happened was they had already passed a version of that bill previously in the Senate before the balance of power had shifted. And so they had a Senate version of Obamacare, they had a House version of Obamacare, and so they didn't actually need to pass it again. So the whole election for Scott Brown was kind of just something that everybody was, you know, excited about for nothing. What they used was the process of reconciliation, which is a budgetary measure where they take a Senate bill that's a little bit different from the House bill, and they just kind of mash them together. And so they can pass that with just a simple majority vote, which is essentially what happened with Obamacare. So then, and recall what a big deal this was, okay? This is the first time. I know many people in America are now sort of okay with the government telling them what to do. You have to do this and you have to do that. Many people, you know, sort of remember an era, I do, when that wasn't the case so much, but now it is. You got to stay home, got to put a mask on. You know, we're really encouraging you to go get this vaccine. Because if you don't, you may not be able to go do these other things. You know, we're going to see where that goes. And so you've been sort of ordered to do a bunch of stuff. Now, many people, when Obamacare passed, were making this claim that Obamacare was the precursor to all of these governmental mandates. Why? Because this was the first incident where the government could mandate that you do something. In this case, it was to go and buy health care. And the rationale there was that if you do not have health care and you get sick, you become a burden to society. So now what we're going to do is mandate that everybody buys it. Therefore, you have to have insurance. You're going to get medical care and you don't become a burden to society. Well, I remember when Obamacare came out, I was in college and I had to go and try to sign up for it. The whole website was broken. Expenses were very high. The whole thing was a mess, right? It was a broken system. And if you sort of, you know, study the origin story of the bill, I think that's kind of the point. They wanted to force you to buy a product. Then they knew that the offerings would consolidate. So if you had 50 healthcare providers, then the next year, you know, a large portion of those couldn't compete. They would evaporate, and the companies would consolidate. And lo and behold, you see exactly what you see today, right? You've got, you know, increased premiums. We're still talking about healthcare. You know, how many years is this? 15 years later, we're still talking about it. It hasn't been solved, and so the whole system was broken. Now, it got passed, and it got challenged because, like I said, this was the first time in the country that the first time, at least something like this happened, where the government could tell you, come into your home, come into your life and say, you have to buy something. You have to go buy health care, right? We've had other sort of, you know, encouragements from the government, but this is something personal that you just have to go do. It's like the first time a government could order you to do something. And so several, you know, libertarians and people who say, well, that doesn't sound right, were up in arms about this, took it up to the Supreme Court and said, can the government actually mandate that you do something one way or the other? And they made all of these arguments, these really sort of, you know, convoluted arguments if you're in favor of it, and some, I think, very, you know, compelling arguments if you're against a government mandate. And what happened was the Supreme Court kind of just came out in a 5-4 ruling, and Chief Justice Roberts, who was a supposedly conservative judge, actually joined in the majority ruling, sided with the left wing of the court, and passed Obamacare. It said that he recategorized it, okay? Essentially took this issue that nobody was really making an argument about anyways, this mandate portion of the bill. Can the government mandate, tell you, order you to do something? We all know that now they can. They can tell you to stay home, do whatever they want, really. But, you know, previously this was a novel thing. So that was the big question. And what John Roberts did, Chief Justice Roberts, is he came down and he said, well, we're going to consider this to be a tax. So we're not going to say, we're going to say that this is, it's not necessarily like you have to go buy a product, right? You don't have to go buy something. We're just going to reframe this and just categorize it as a tax. And we know that the tax, we get taxed everywhere, and there's nothing you can do to contest that. So they just took this mandate to go buy a physical product, a service, insurance from their marketplace. It's sort of like, hey, we're mandating you go buy this, a car. Well, I don't need a car. That's too bad. We think you do. So you have to go get it. Well, what if I don't want to get it? Well, you're going to be a burden on society because you can't transport yourself. Well, I don't need transportation. Well, we think you do. And there's going to be a big problem if you don't get it. We're going to tax you. And so the government then funnels you into their little marketplace where they've got the control of the marketplace, and they can sort of, regulate that to their heart's desire, and they can break the healthcare system, essentially. Healthcare system is kind of a disaster. We saw how good it was the last year. In fact, they told us we had to lock you down because of the problems with our healthcare system, the overcapacity. We can't deal with this. We're not properly prepared. We don't have enough PPE, and the list goes on and on. So they say that they know what they're doing. They have no idea what they're doing, as is plainly evident by the last 12, 14, 16 ongoing months that many of us are living through. So let's go back to now the journey. So the Supreme Court comes back out, says you are now mandated to buy this stuff. And you have to do that because it's just a tax. And we know there's a long precedent for taxation in this country. Every single tax is justified for whatever reason because the government, that's basically what they do. So that happens. And then the balance of power starts to shift a little bit. So we see that the Republicans take control of Congress, and so they don't want Obamacare in place. So they start to unring that bell. This happened during the Trump administration, and essentially what they did is that mandate that John Roberts said that we all have to endure is now there's a penalty if you don't comply with the mandate. They don't round you up and throw you into jail, but they'll start to assess a penalty, and that penalty will get worse as the years go by. The more and more out of compliance you are, loosely speaking, the worse the penalty you get. So they said, because that is the penalty, the Republicans were going to just get rid of the penalty. So what good is a mandate if there's no penalty? It's sort of an enforceability issue. So you can pass all the laws in the world you want, but we're just not going to enforce them. Okay, it's sort of like how the marijuana statutes exist right now. It's still illegal federally, but there are many states across the country that are just saying, well, it's legal here. We're not going to enforce your federal laws. If you want to come in and enforce them, you can. The government is not doing that. So it's an enforceability thing. So the government, the federal government says here, yep, you got to get a mandate. You have to buy this health insurance. If you don't buy the health insurance, we're going to penalize you. The Republicans come in and say, well, we're just going to gut the penalty. There is no penalty anymore. And so then the next question, logically, of course, is if there's no penalty, then what good is the mandate? And if the mandate fails, well, doesn't the entire bill essentially fail? It's the nuts and bolts argument. If the mandate fails, and it should because it isn't a tax anymore, right? Because there is no penalty. It's a zero penalty. So if it's a zero penalty, then how can that still be a tax? It's not a tax anymore. So then the rest of the bill has to fail. That's the argument. It's gone up about 3 times now, and the court every single time has knocked it down. Okay? And that whole spectacle was for this bill. Okay? A lot of effort went into this. So they are not going to allow that to go anywhere. All right, CNBC gives us some background here. Obamacare survives the latest challenge. Supreme Court ruled against Texas and other Republican-led states seeking to strike down the Affordable Care Act in the latest test before the nation's highest court. Top court voted 7-2 to reverse the appeals court ruling, struck down the law's individual mandate provision. Okay, so there was a lower court. We're going to go into this a little bit in more detail. These are just the highlights. The 2 of the former President Donald Trump's court picks, we got Kavanaugh and Amy Coney Barrett. They joined the majority in rejecting the Republican effort. And again, we're going to see, this is not about the underlying tax issue. This is not about whether it's a good idea or bad idea, good system, broken system, anything. This is about whether these Republican states like Texas and some of these other entities have what's called standing. So do you have the authority to even bring a claim into our court? The Supreme Court is going to tell us here in a minute, no, we don't want to hear from you. You have no ability to file a claim. And pin this for a minute. The basis being There is no tax. Okay, there is no penalty because it's been reduced to zero. So put a pin in that. We're going to come back to that. So what happened today at the end of the ruling? Of course, President Joe Biden and cited this as a major victory, of course. So let's go over to the SCOTUS blog. And Amy Howe is going to give us a little bit of a breakdown here. Much anticipated decision, she says. The Supreme Court rejected another effort. Justices did not reach the main issue in the case, right, which is whether the entirety of the Affordable Care Act was in fact rendered unconstitutional when Congress eliminated the penalty for failing to obtain health care. As I explained, if this is not a penalty anymore, then how is it a tax? Therefore, how could it be constitutional? So they didn't answer that. They just said instead, well, we're just going to vote 7-2. They said that neither the states nor the individuals that are challenging the law have a legal right to sue. This is known as standing. Okay, we talked about this back during the election litigation. The courts were saying, well, I mean, you can sue us if you want, but you're not Donald Trump, so you don't get to file a lawsuit. He can file a lawsuit. Then when Donald Trump filed a lawsuit, then they found a bunch of other garbage reasons why why his lawsuits should be thrown out for whatever. We talked about all the justiciability elements when we were going through all of that. Not going to rehash that here, but Justice Stephen Breyer here wrote the opinion. Two other liberal judges, Sotomayor, Kagan, 4 conservatives, Roberts, Thomas, Kavanaugh, Barrett, Alito, wrote a dissent and was joined by Gorsuch. So how does this break down? Let's take a look over here. SCOTUS always does this, and they do a nice job. So you're going to see here we have the left side of the court, which of course we've got Sotomayor, Kagan, Breyer, and then we've got Roberts over here. So he voted with the left. And then we've got Trump's 2 most recent appointees here. We've got Kavanaugh, member Kavanaugh, and then we had Amy Coney Barrett, who basically, flew through confirmation. Kavanaugh's was a little bit more, rocky, but they're joining here. And again, they're not joining on the underlying issue. They're just saying standing. There's no standing here. So, and Judge Roberts also joined in. We've got Alito and Gorsuch bailing out. So if you look at by seniority, doesn't really tell you much there, but kind of shows you how the breakup of the court is. So let's go through and see what exactly happened here, because I want to explain the standing portion of this. And let's recall again what the argument is. The argument is that there is no constitutionality of Obamacare. Why? Because it originally it was constitutional because it was categorized as a tax. We know the government has the ability to tax. Now that the government has basically wiped out the tax portion of the bill, how can it be still categorized as something that's constitutional if it's plainly not a tax? Okay, so watch what happens. Because the fact that Congress reduced the tax to zero, as we're going to see, is the very thing that gives them no standing. This is when you're going to see what I'm saying here, but watch this. All right. Unlike the tense 5-4 ruling that was issued in a prior case, the court's decision on Thursday was not close. 6 justices joined Breyer's opinion that neither the states nor the plaintiffs have standing to challenge the mandate. The individual plaintiffs, Breyer explained, they said that they are harmed. Okay, we're suing. They're saying, hey, we're harmed. We have a right to sue here because they have to pay each month for health insurance to comply with the mandate. Breyer says, well, the problem with that argument is that even though the Affordable Care Act tells them to obtain health insurance, the IRS, it really can't impose a penalty anymore if you don't get insurance. So there's no other government action connected to the harm. So there's no standing. So do you see what happened? So because Congress reduced the penalty to zero, the court is now saying there is no harm to you people. So you can't sue us. What are you complaining about? Well, we say the Affordable Care Act says that we have to go get health insurance. And they say, yeah. So what if you don't go? What if you don't go get it? They say, well, nothing. The IRS can't impose a penalty on me because the Republican Congress gutted the law. So the court says, okay, well, then what are you suing for? You can't come in here and sue. You haven't been harmed yet. So the next, of course, question would have been, well, why didn't the Supreme Court take the case? Or maybe they're going to argue that they did when there would have been standing. So they accepted the case to hear it and then throw it back out and say there's no standing. All right, let's finish this and then we'll do a little bit of analysis on it. Breyer continued, nor do the states have standing to challenge the mandate. So if you're an individual person, you can't sue anymore because you don't have standing because the penalty is zero. Also, if you're a state, you also can't sue. Although they allege that they are injured because their residents, they say, in an effort to comply with the mandate, they enroll in state-sponsored programs like Medicaid. It costs the state money. Breyer emphasized that the states have not shown a link between the mandate, which is unenforceable, and the decision to enroll. So he says no standing at all. So my point here is that the law can just be finagled however you want it to. You know, that you can call it a tax, pass it, reduce it, gut the tax out, invalidate the constitutional underpinnings, say, well, it's not really a tax anymore. So rather than the Supreme Court saying, oh, it's not a tax anymore, so we're just going to invalidate the law, right? They can't do that. So if somebody else sues and says, okay, well, since it's no longer a tax, we're going to sue, we've been harmed by this bill. They say, oh, no, you haven't been harmed, actually, because it's not a tax anymore. So we're just going to leave it in play. So it's just like a boxer just dodging everything, right? No, we're going to do everything humanly possible to make sure that this stays in place. And it's not going anywhere. So if you're betting on Obamacare evaporating, it's ensconced. Every single element of this institutional power structure, Republicans, Democrat, what doesn't matter. It's sticking here, and it's probably just going to continue to snowball, as we all know, right? In his dissent, Alito described the court's ruling as the most recent chapter in our epic Affordable Care Act trilogy. He lamented that the ruling follows the same pattern as installments 1 and 2. He says, with the Affordable Care Act facing a serious threat, the court has pulled off an improbable rescue. Alito would have held that the states have a right to challenge the mandate. He would have then ruled that the current version of the mandate is unconstitutional. And as a result, the rest of the ACA should also be invalidated, which, of course, is the right legal justification. Because we all know that in the current version of this, if you sort of add all of the court's positions on this together, they can't find that it is still constitutional. So they have to throw it out on standing because they don't want to hear the case. Useless. All right. Next up, we've got, now here's Barack Obama now. He's very happy about it. He says, today, the Supreme Court upheld the Affordable Care Act again. Right? Third time. He's right. This ruling reaffirms what we've long known to be true. It is here to stay. Barack Obama is right about that. No question about it. So Supreme Court, let's see if they get, another case. Let's see how they do on this one. So Supreme Court here sides with a Catholic adoption agency that refuses to work with LGBTQ couples. So we're going to go through this one. This one is a little bit more complicated because there were two issues that were sort of intertwined in this one, whether they were going to revisit a prior case called Employment Division versus Smith. So we're not going to really spend time on that issue. The bigger issue here is really about the relationship between a lot of different moving parts. We've got the city of Philadelphia, and they are in a position where they're facilitating adoptions. And there is an adoption agency that is affiliated with the Catholic Church called the Catholic Social Services Organization. And so, of course, they've got a religious affiliation, but they help place children with adoption families or foster homes or, whatever that's called these days. I don't mean to be pejorative there, but it's a complex relationship. So we have LGBT couples now who are wanting to work with the city. We have the city now who may be trying to contract with Catholic Social Services, and you can see where there may be a conflict of interest, maybe, religiously speaking, or, ethically or morally or whatever, between all of those different parties. People have different beliefs about what's appropriate with adoption, and now you're talking about bringing the government in and helping to facilitate these different relationships. So in Philadelphia, then, what they said is, essentially, we're going to prioritize the LGBT couples and adoptions with them, and we're not going to contract as the city of Philadelphia with the Catholic Social Services because Catholic Social Services is discriminatory towards the LGBT couples. So basically what they're talking about is the Catholic Church was not able to contract with Philadelphia because of a religious exercise, because of a religious belief. Catholic Church now says, hey, that's discriminatory. We're just working in accordance with our religious beliefs, and the fact that you're essentially voiding a contract with us is problematic. You are infringing on our rights. You're giving contracts to everybody else, but not to us. just because we're Catholics. So let's take a look at what's happening here. The Supreme Court now is siding with the Catholic Adoption Agency, and it's not even close. It's a unanimous opinion, if I'm not mistaken. Let's take a quick look and make sure. Yeah, it is. So we're going to go through this. Supreme Court sides with the Catholic Adoption Agency that refuses to work with these couples. So the Supreme Court on Tuesday, it was a unanimous defeat to the LGBT couples in a high-profile case over whether Philadelphia could in fact refuse a contract with a Roman Catholic adoption agency that says religious beliefs prevent it from working with same-sex foster parents. Okay, so obviously that's a provocative thing. People have strongly held beliefs on that topic. So this is, of course, going up to the Supreme Court. Chief Justice John Roberts wrote in an opinion for the majority of the court that Philadelphia violated the First Amendment by refusing to contract with Catholic Social Services once it learned that the organization would not certify same-sex couples for adoption. So we're going to get into this in a little bit more depth, but again, we've talked about this in prior rulings. Here is another case where we have a unanimous decision, unanimous by the Supreme Court, and many people are sort of scratching their heads about this, right? It's not something that you typically see often. In law school, we read a lot of split decisions, a lot of 5-4s, a lot of close, sort of landmark cases that are close. And we've seen very consistently out of this new administration, this new term, what kind of feels like a lot of people, I haven't done any analysis on it, but other people, Jonathan Turley and other people are commenting that this is seeming like a lot of abnormal unanimity here. 9-0s across the board. What's going on? And of course, we're speculating, but the idea from the Supreme Court might be that they have some pretty rock solid cases that are going to be detrimental, or I shouldn't say detrimental, but let's say controversial, coming soon, right? Big ones. I'm talking about abortion specifically. So we've got Nancy Pelosi's already being asked about that. We're going to talk about that here at the end, but bracing for impact, in other words. So the Supreme Court is saying, look, we can get along. We can be friends. 9-0, 9-0, 9-0, 9-0. So that when it comes down in a 5-4 or a 6-3, maybe on Roe versus Wade, which I'm not really of the mindset that that's going to be overturned or anything like that, but we'll see. If it is something that's close, what are you going to hear from the media and everybody on the left if it is overturned, which I'm not particularly optimistic about? We'll see. If it does get overturned, it's going to be a hyperventilating screech fest that is going to be really, really painful to endure, because they're going to say that the court was biased, that the court was overly conservative, and that's going to justify the packing of the court, right? It's going to justify the Democrats taking action and doing something to sort of reverse that. So we'll see what ends up happening. Let's take a look at this ruling so we can get some framework for the future. So here we are again going to go over to SCOTUS blog. Amy Hound does a nice job here. Says that the court holds that the city's refusal to make referrals violates the Constitution. So in a clash between religious freedom and public policies, we have these two competing interests. Catholic Church says, hey, it's just free speech, or it's free religion, or free exercise of religion, to be more specific. And the city is saying, well, we've got public policies that protect the LGBTQ community. Supreme Court ruled on Thursday that Philadelphia violated the First Amendment's free exercise clause when the city stopped working with the Catholic organization. Again, they were not certifying same-sex couples as foster parents. So foster parents would go to the Catholic community. They would say, hey, we want to adopt a child. Catholic organization would say, sorry, we're not going to certify you to do that. So Thursday, Amy says, is a victory for Catholic Social Services. They're associated with the Archdiocese of Philadelphia, the Catholic organization, and two foster parents who allege that Philadelphia's refusal to make foster care referrals to CSS discriminated against the group. Okay, so this is two foster parents now who actually, it sounds like they're bringing the lawsuit, suing the city, saying, hey, you didn't give a referral over to them. Maybe these are two Catholic parents that want to go through the Catholic Social Services, but they are not getting an opportunity to facilitate because Philadelphia said you're discriminatory. The decision fell short of the broad endorsement of religious freedom that the challengers had sought, but the justices unanimously agreed that the foster parents at the city's action was unconstitutional. 6-justice majority left intact the prior ruling. So they didn't overthrow that case. So you can see here, same type of division here, right? We've got total unanimity, if that's a word, right? Absolutely unanimous. And not much else to say there. We've got different opinions here on this second case, but again, that's a secondary issue, so we're not going to mention that. This case, as we sort of have deduced thus far, started in 2018. Philadelphia City Council, they passed a resolution. They said no discrimination. They stopped funding and making referrals over to CSS once they found out how they sort of refused to certify people. CSS to foster parents. We've got the Sims Bush family. They went to federal court. They sought an order, so they were demanding that the city start sending referrals back over to the church. They said that cutting them off was a violation of all their rights, and the Supreme Court ultimately agreed with them. Roberts began, he said, it was plain that the city's actions had burdened CSS's, which is the church's, exercise of its religion by requiring it to choose between curtailing its mission or approving relationships inconsistent with its beliefs. The question before the courts was whether the Constitution allows the city to impose that burden, and the court said no, right? So this is a unanimous decision. So when you have cases like this, it really blunts the argument. This is why I keep bringing up these 9-0 decisions, okay? Because you can sort of just venture out how this argument would have gone if this was let's say a 6-3 decision. Let's say 6 conservatives voted against the LGBTQ community and the 3 liberals voted in favor of them. If this was a political case, could have easily been. What would have happened, right? The narrative would have been, well, we've got a bigoted court up there full of a bunch of racist conservatives who are xenophobic or whatever label you want to use. That undermines the court's credibility. It reduces their legitimacy. And we've said this many times here when talking about the enforceability, how these different governmental bodies function. The Supreme Court is based on legitimacy. The executive, they've got the Justice Department and the FBI. Legislative branch has the power of the purse. Justice Department, it's kind of just, the courts, judicial department is just kind of, hey, it's because we're legitimate and sort of rely on the other 2 branches. So what we're seeing are a consistent showing of unanimous rulings so that it blunts that opposition. It's hard to come out now and say it's a bunch of racist, bigoted, xenophobic, anti-LGBTQ people up there if the 3 liberals also agreed with them and said, hey, yeah, it's a free speech, it's a free exercise of religion argument, and we went through the rules and this is what we say. So that the next time that it does get controversial, maybe they can point to their track record of working together. We'll see. Now, abortion, it's next up. We all know that's coming down the pike, and the media is ready to go with it. So a reporter here from CBS News said, hey, Pelosi, is an unborn baby at 15 weeks, a human being? She says, well, let me just say I'm a big supporter of Roe versus Wade. I'm a mother of 5 children in 6 years. I think I have some standing. So she's got standing. She's on this issue as to respecting a woman's right to choose. So here's Representative Pelosi.
Thank you, Madam Speaker. I'm with CNS News. The Supreme Court this fall will review a Mississippi law that bans most abortions after 15 weeks of pregnancy. Is an unborn baby at 15 weeks a human being?
Let me just say that I'm a big supporter of Roe v. Wade. I am a mother of 5 children in 6 years. I think I have some standing on this issue as to respecting a woman's right to choose.
Is it a human being?
Yes.
Speaker,
Yes, ma'am.
And we're going to go to the next question. Does not want to answer that one, right? Well, I'm a big supporter of Roe versus Wade. That's a perfect political answer. She's not bad at just skimming right over some of that stuff. All right, so let's take some questions over from watchingthewatchers.locals.com. Thank you so much for your support over there. That's where the live chat happens every day, and there's a lot of good stuff happening there at watchingthewatchers.locals.com. First up in the house is Want to Know says, wasn't that 1,000 pages of documents dumped on Congress and idiots voted for without even reading it? Our Congress at its finest. Yeah, I think this was the one where Pelosi, actually, speaking of her, came out and said, well, we have to pass the bill in order to find out what's in it, because they don't want to actually read it. That's a lot of work. We've got Want to Know says Biden and Kamala looked good giving out a new federal holiday that is a paid day off for Miss Faith or at least double time. Thank you. Some just get the day off with no pay. So I don't know. Didn't they just pass this like today? I don't know what our policy is here. I'll have to ask Miss Faith what our policy is. I'm sure she'll give me some good guidance on that. So we have a new holiday. It's a federal holiday, and it's paid off. Another paid off holiday. That's great. That's really good. Happy about that. We've got Kelly Stew says, so could we get a refund for previous years over there on the Obamacare plan? Can you get a refund on because it was reduced to zero. We all paid a bunch of money for, subpar healthcare, and Kelly wants to know, can I get a refund back? Can we call our credit card companies and reverse the charges on our federal government? Speech Unleashed says, do you think maybe the SCOTUS are making deals with each other? Yes, I do. For instance, the conservative judges tell the liberal ones, we're going to side with you on the Obamacare case, and then you will side with us on the Catholic adoption case. So I don't think that it's necessarily sort of like that obvious, right? It's like a trade-off. But I absolutely think that they're negotiating, or they would never categorize it that way. So I want to be careful here, right? I don't want to speak out of turn with the United States Supreme Court, but certainly, right, we know that legitimacy is a big concern with the courts, and in particular with Chief Judge Roberts, somebody who's talked about it a lot, and we've seen him historically sort of kind of be the waffler in the middle. And I've speculated that I think he waffles and sort of joins one side or the other for that very purpose. I mean, just to be sort of a negotiator. He's less concerned, in my opinion, right? This is just an opinion, about the legitimacy and the long-lasting legacy of the court under his leadership than with any particular issue. Okay, he's going to be on the bench as the chief judge for 50 years. And when we're reading in our legal books, that's kind of what we talk about. We talk about, the Burger Court, and we talk about these different eras, kind of these epochs over the jurisprudential history of the Supreme Court. And it's not, when you review the court through that lens, it's not traditionally about any one case, unless it's something like, Plessy versus Ferguson or something. But it's more of a tone, a legacy, and I think that's where Roberts is more concerned about. He wants to see the tone move forward, less so than any particular abortion or Obamacare, right? He definitely did not want Obamacare to be a defining case for him. We have a new president. We have a lot of energy behind Barack Obama, and this thing got passed. It was sort of a weird time in the country. Everybody had this insane euphoria for some reason. Hope and change. I don't know if you remember that. Hope and change. About what? I don't know. Something. Everybody was hopeful, and they wanted some change, and they were going to get it, and they were really excited about it for some reason. But it was a weird era. And so for the court to backpedal against Obama at that time just wasn't palatable. And I think that's why Roberts twisted himself into a pretzel in order to make Obamacare into a tax, which, I don't remember at the time, but I kind of recall thinking everybody was saying, what? Who argued it was a tax? Where the hell did that come from? It was just some argument that the court just made up. Oh, it's a tax. Okay, so that's good. Maybe it was in there somewhere. It's been a long time since we talked about that. But let's take a quick look over here. We got ATB Kelly 100 says, I find myself in a strange position that I'm not necessarily opposed to the concept of abortion, but I do think Roe versus Wade is a ridiculous opinion that should be overturned. Is there an avenue through which the court can uphold the right to abortion, but still overturn the opinion? Or would the legislators need to do something instead? Your potential future associate from Chicago. What's up, my future associate? Love that. Yeah, come on down, baby. We want the best here. And you sound like you're onto something. So here, let me run you through this analysis a little bit. The Roe versus Wade issue in popular culture, in my opinion, has really been about a woman's right to access abortion. In legal communities, it's sort of viewed a little bit differently, at least from maybe those. So, for example, I am not a fan of how this issue was decided. Without making commentary about abortion, I do not like what the court did with the case. Okay, and the reason being is because the court acted like a legislature. They basically said, we're going to pass sort of a congressional type bill. We're going to pass a new law that we're just going to basically write, and we're going to make up out of nowhere. It doesn't come from the Constitution, doesn't come from anywhere. So the court was acting like a Congress in a sense in Roe versus Wade. And they did so by creating this sort of three-trimester or this this like thirds, this trimester framework where they would say, well, in the first trimester you can get an abortion. In the second trimester, it's okay if the government puts some restrictions on it, and then in the third trimester, there's another framework for how states can deal with somebody who's in their third trimester. And so they came up with this framework, and everybody's going, what? Where the hell did that come from? You're supposed to be talking about constitutional provisions, and you're supposed to be sort of ruling and weighing issues that are weighed against the laws. You're not supposed to be creating the laws. So the fact that they just sort of concocted this thing out of thin air without any commentary about abortion, not one way or the other, right? That's beyond the scope of this conversation. But that issue was troubling because a lot of people said, well, that's not how the courts work. If you want to legalize abortion and make sure that that is something that is fundamental and can't be challenged and all that stuff, the courts are not the appropriate place to do that. The other appropriate place to do that would be the legislature. Okay, now the converse argument to that is sort of what you see in the lineage of the Roe versus Wade cases, which is more about this sort of separate concept, going away from that 3 trimester framework. The first trimester, certain regulations, and they sort of get the relationship there in the Roe case was more about this sort of inverse relationship. As society started to gain more interest in the life of the fetus, then it became more reasonable to allow the government to regulate abortion further. So as a child, or as let's say a fetus or a zygote or whatever, when it becomes a, what's the word? Inseminated, when it becomes a zygote, whatever it is. I was one. I used to be one. I don't even know what it is. But when I was first that little thing down in there, at that moment, there's still debate about what that is and what that means. And so the framework, the court in that framework said, well, the state doesn't have as much interest in that life form or that clump of cells, however you want to define it. But they said as that matures and as it grows, it starts to resemble sort of more a human, and society is kind of invested in the development of that person. And so now we have more interest. The government can have more interest in wanting to protect the unborn. So it's this inverse relationship. And that's why they created this 3 trimester framework that they just pulled out of their rear ends. So in the next lineage of cases then, it went away from that. And they just started to say it was about a constitutional type of right, about access to, right, this is where the right to choose comes in, and that anything that infringes upon that is in the Casey versus Planned Parenthood lineage of cases, talking about an undue burden on a woman's right to choose. And so the framework changes a little bit. And it does so without explicitly overturning Roe versus Wade. So, do I think that a woman's right to abortion or anything like that is on the way out in this country? I don't think so at all. So, I think your question is on the mark here, because you're talking about, can the court still uphold abortion or uphold the provision, or still sort of protect a woman's right to to access those things while overturning Roe versus Wade? And I think the answer is absolutely yes, because the progeny of the Roe cases has sort of gone down this undue burden trajectory, where the analysis there is whether or not a government law is placing an undue burden on a woman's right to an abortion, which is, you think about these things in terms of, I am not an abortion connoisseur, okay, here with the case law, the jurisprudential stuff here, but they talk about some of these undue burdens here as delaying a woman's ability to get an abortion if you require her to listen to a heartbeat or listen to an ultrasound prior to getting an abortion. They say that maybe is too dissuading. And so it's a very complicated situation, and it's not one that I venture into often, but it is going to be in front of all of us here very soon. And of course, it's going to be very, very volatile. And of course, I do not want to get into the volatility at all about this particular issue. It's not really my wheelhouse, candidly. I spend a lot of time in the justice system, and that's more of a cultural issue. But I do think that it is something we're going to be talking about. We're going to be covering whatever the case looks like here, certainly. And so just brace yourselves for that. All right. And so great questions. Thank you for that. Future associate from Chicago, future associate ATB Kelly is going to be in the house, which is great because we're going to need some help at our law firm, the R&R Law Group. You can see right here, we do a lot of stuff We need some great help regularly. So we're always looking, honestly, this is not a joke. We are always looking for good people to join our team. If you're looking for something, always feel free to send us a resume and an email to employment@rrlawaz.com. Those are going to go to Miss Lily, and she'll be able to take good care of you. Let's get back to the plug. Here's what we can help with: felonies, traffic tickets, drug charges, of course, DUIs, misdemeanors, domestic violence, all that stuff. QR code will take you to our website. Phone number for a free case evaluation is 480-787-0394. And I know many people say, Rob, I will never be in trouble. I will never, ever have a need to call you. That's true. But that might be because you've taken a course like this called Law Enforcement Interaction Training, available now at gumroad.com/Robert, which is where I have some great courses that you can buy, and you can support the show by following me here. Throw that email address right in here and download the Gumroad app on any one of these app stores. But the course that's really going to be something that's worthwhile is this Law Enforcement Interaction Training course. 2.5 hours of some good stuff. We got into it. There is a 1, 2, 3 rule for dealing with law enforcement. There's only one rule. 2 is the 2 questions that a police officer can ask you. Number 3, the 3 responses if they ask you a question that is not one of the other 2. See how that works? Pretty clever. So go check that out. Available at gumroad.com/Robert. And thank you for all of your support.